Hello everyone. I hope I am audible to you. I hope I am audible and visible to all of you. Okay, so I think there are not many people joining us today. So instead of waiting for them, maybe we can just start with the session, and after that, we are obviously recording the session, and they may just take the help of the recorded lecture later on. Okay, so yesterday we discussed about what is an offense. Then we made a distinction between offense and crime. Uh, Guys, is this whiteboard visible to you? If anyone of you is not able to view the whiteboard, kindly let me know. Okay, I think it is visible. Okay. So yesterday we discussed about what is an offense. It defined under section 40, and it has uh, it means something which is punishable under IPC, which is made punishable under IPC, and from this we draw implication that something which is not punishable under IPC, something which is not punishable under IPC will not be considered to be an offense for the purpose of IPC. And then we just read the definition of offense under section 40, which talked about a thing punishable by IPC, a thing which is made punishable by this code, which is IPC. Okay. And here we talked about also that what does this thing mean? The, the thing here means the consequence of human conduct. Consequence of human conduct, or this conduct, like one of you also suggested that it is the act. Yeah, it includes act as well. It includes act as well as illegal omission. If we read this with section 32 of IPC, then here act will include illegal omissions as well. Okay. And here we talked about that it is the consequence of human conduct which is made punishable under IPC, and it is what is called an offense for the purpose of IPC. Then further we discussed about just a sec. Then we discussed what is actus reus. Actus reus is basically, actus means act, conduct, as I mentioned here also, that it is the conduct or act. And res means something which is forbidden by law. Okay, so these were the things which we discussed yesterday, and Yeah, this was it. Okay, so let's start with the mens rea today, as we had planned that we will be starting with mens rea. So mens rea. See, this Rias and Ria are basically the same thing. In the sense, Rias is used as to imply something which is singular, and Ria is something which is plural. That's all the differences. So here also Ria will mean something which is forbidden by law. And mens is the state of mind. It is the state of mind. So tell me, how will you like say that this is mens rea? Like, how can you come to know what is the mens rea of the accused or the person who is being tried? That he had the requisite actus reus as well, because actus reus can be imputed or can be we say we can come to know about the actus reus because it is basically the conduct or the consequence of human conduct, and that conduct and that consequence basically is somewhat which is explicit and can be seen from our eyes, and can be or its implication can be felt. So actus reus is somewhat, I would say, we can find it very easily, but the state of mind, which is the something which is in the mind of the accused, how will we come to know about this thing, that this the state of mind of the accused was there at the time of commission of the offense, and it is that with that particular mind he was able to, or he did that act which led to that particular consequence, and that consequence is basically punishable by law. Tell me, how will you find this mens rea or the state of mind? Intention to do something illegal, guilty state of mind. Intention to do something illegal. Okay. So intention is, yeah, we can say mm, mm, type of mens rea, but it is not the only mens rea. Mens rea is of three types. First is intention. Then we have knowledge. Then we have reason to believe. In short, I'll write it as RTB. So if someone does an act with the particular intention, so we say it is the highest degree of mens rea, because when someone has intention to do something, then we expect him to be extra particular about that act, in the sense that he or she will be particular that that act will produce the particular consequence only, and that is the that is what that is why we say that it is the intention, is the highest degree of mens rea. Knowledge is somewhat, we say that, yeah, if someone does an act with the knowledge that then he basically has he basically has that thing in mind that maybe or maybe not that consequence can be caused. So knowledge is somewhat a lower degree of mens rea. And when we come to reason to believe is the we say a slight lesser degree than knowledge as well, that person is doing something just and that thing or that act may produce the particular consequence or not. So this was about mens rea. And just now, as I told you yesterday also, that these actus reus and the mens rea are basically the elements of a crime. Actus reus and mens rea, these are basically elements of crime. Oh, these are basically elements of crime. So if I draw a diagram here, suppose this is actus reus and this is mens rea, and they both have this thing in common. So this is what is offense or crime for the time being. This is crime. And for the purpose of IPC, if it is made punishable under IPC, then it is what is offense. Okay. Just let me know, guys, if you have understood this. And if not, then I will just explain it once again. Got it. Okay. Okay. Thanks a lot. Thank you. So what happens is now, just have you guys ever heard about a legal maxim which is actus non facit reum nisi mensit rea, something like that? Because you must have read about it in law of torts, I guess. Actus non facit reum nisi mensit rea. What is this? It is basically telling us that an act cannot be guilty unless it is accompanied by a guilty mind. This is what is this magazine is all about. I'll discuss this magazine in later session of the class. Don't worry about it. We have to discuss general exceptions today, right? So I will be just first once this revision is done, then I will be coming to the general exception part, and in that I will be explaining you again what this magazine is all about. Okay. So I guess this is all for this one part of this. Then we have to discuss one more thing, which is related to actus reus only. See, guys, actus reus is, just now I told you, consequence of human conduct, and this is the act which is forbidden by law. Guys, I told you yesterday, who decides that it is forbidden by law? Tell me. Who decides that whether an act is forbidden by law or not? Yes, it is the people or the societal perception. It is the society which decides that this particular act is what we say is not permitted or is against the societal perception, and hence it is declared to be forbidden by law, and hence it is made to be punishable. Yesterday we talked about this, right? So this is what uh, I had to tell you about this actus reus and this mens rea concept. And in order to look like as you guys also must have heard about this thing, that crime is basically a wrong against the state, against the society. Crime is against the state always. But why is it considered a wrong against the state? Tell me. And tell me, why is it considered a wrong against the state? Yes, it is considered as a wrong against the state because state consists of people. Yeah, state consists of people, and people together make the society. And this this is the society which actually declared it to be forbidden by law. So it is but obvious that since it was done against the state, which is the people and which were formed by the society, so this society will be prosecuting the accused. Yes or no? Right. So that's why if you have like come across some of the cases, it is always the accused. In cases, it is always the accused. In criminal cases, accused versus state. It may be the state of dash dash dash. I won't be naming any, but there are many cases like state of UP or state of Haryana. So these are the cases against the these are the offenses, or the crime is always against the state, and it is the duty of the state to try the accused, and if found guilty then punish him. And it is also in the interest of the society only that the accused should be convicted and should be brought before the court, in order to create a sense of deterrence, or in order to bring a cohesion in the society, that if someone in future does this kind of an act, then he will be tried before the court and will be convicted. So this is the main reason why crime is considered to be a wrong against the state, and it is the state who prosecutes the accused. Okay, so after this, maybe we can now start with the general exceptions part. General exceptions. Okay, so what are general exceptions? Tell me, what do you think are general exceptions? Defenses. First answer. No. Yeah, these are. It is. Yeah, we can say that these are defenses, but it is not the correct term. General exceptions are basically defenses only. It is not. It would not be wrong to say that these are not defenses. These are defenses. Any other person who can give answer? Okay, I'll tell you. So general exceptions from section 76 to 106 provides us various situations like mistake, then we have uh, someone who is legally justified, then also we have minority. If the person is minor or the accused is minor, here we have two. If the person is below 7 years, if the person is below 14 or 12 years. Okay, so these are the various kind of uh, general exceptions which we have. It is under 12 years only. Yeah, it is 12. Okay, so now before starting with these sections and all, what do you think is the purpose or the reason why we have these defenses, these general exceptions as defenses? What do you think is the reason behind the general exceptions? Purpose of general exceptions. Look, crime is basically an offense against the state. Okay, it is an offense against the state. State consists of society. So it is basically an offense against the society. So anything and everything which shakes the societal balance or which shakes the societal conscience will be an offense or will be a crime. Now, if the societal balance is shaken, then it will be a crime, right? And we also discussed that elements of crime, elements which is actus reus and mens rea. Now let's go from this side. Okay, if a person does an actus reus or the or does an act which produces a consequence which is forbidden by law with the prior mens rea, that which is the state of mind, and that consequence shakes the society, then it is the duty of the state to punish him, right? But if if any of these, actus reus or mens rea, if any one of these is absent, then what will happen? Tell me. If either actus reus or mens rea is absent, then what will happen? Okay, yes, then act wouldn't be a crime. Now, since you have told me that if actus reus or mens rea, either of them is absent, then it would not be considered to be a crime. Then it will somewhat, we can say that that consequence which was produced by this actus reus will not shake the society. Hence, the state would not punish him, right? And I told you in this class only, actus reus, mens rea, this is offense, right? I told you about this. Now, I just now asked you, and one of you also told me that it won't be a crime. But what about, what do you think if there is a case of strict liability? In strict liability, those of you who don't know that, we don't see the intention or the mens rea of the accused. We just see the actus reus. That is the consequence. If a particular consequence is produced, then the act will be punishable and the accused will be punished. Okay, so in order to commit a crime, apart from this strict liability cases, the presence of actus reus and mens rea is important, right? So even if a person commits a crime, that is the consequence of human conduct, actus reus, without this mens rea, it won't be considered to be a crime. Hence, the society will not be punishing him. And this is what is the purpose of general exception is that if a person does some act without a prior knowledge, intention, or reason to believe to produce that particular consequence which is forbidden by law, then that act, then the state rather would be having a sense of forgiveness towards the accused, and hence that act will not be considered to be a crime or offense for IP for the purpose of IPC, and hence it will not be punished. Tell me, have you guys understood what is the purpose of general exception? We have been provided certain situations in from section 76 to 106. Basically, from section 76 to 95 are some situations, and from 196 to 106 we have private defense. Okay, tell me, have you guys understood what I meant to say? What is the purpose of general exception? If you have not understood, kindly let me know. I will explain it again. Okay, so I am not receiving many messages. Guys, tell me, at least reply. whether you have understood this or not understood this, I will explain it again. No issues. These are not something which you come across in your day-to-day studies. Okay. Okay. So let's start with general exceptions. The first and the this is the provision which is most used by the defense or the accused in almost I would say it is the most used section in the chapter of general exceptions. General exceptions is chapter number 4. If you guys are not aware of it, it's chapter 4. Guys, are you guys having the Bear Act with you, or should I open it again? Okay. This no is that you have not understood or you don't have the Bear Act. I have received 2 to 3 no's. No Bear Act. Okay. Wait. I'll just open the Bear Act in front of you. Okay. Are you guys able to see the screen now? I have opened the Bear Act for you. So, what section 84 tells us is nothing is an offense which is done by a person who at the time of doing it, kindly make a note of these terms, guys. At the time of doing it, this is very important term. The time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Okay, so I'll just break this definition. Section 84. Okay, it starts with the term nothing. What do you mean by nothing? Nothing is basically no thing. Okay, and this thing is what which we talked about in offense, that is the consequence of human conduct. This is what is nothing is here, what they mean by nothing here. Okay, so it starts with the term nothing, which is we say was present in the definition of the term offense also. Now, uh, just to inform you guys one thing, that this section 84 is basically dealing with unsoundness. Okay, now this unsoundness is of two types. First one is medical unsoundness. Then we have legal unsoundness. Okay, so firstly, what happens is it is kind of what we say, it is the medical unsoundness which leads to legal unsoundness. Okay, if a person is medically unsound, only then this person will get the defense of legal unsoundness. Are you guys following? Okay, now one more thing which I want to tell you is, see, in a criminal trial, how the trial is conducted. Okay, so the it is if you guys have read section 101 of Indian Evidence Act, then you will come to know that the burden of proving the case is upon the prosecution. So it is always the prosecution who proves the case, and it is we say it BOP, burden of proof. In our case, since the offense is conducted or the crime is conducted against the state, so it is the state who will be prosecuting, and the burden will be on the state, and state is represented by prosecutors who prosecutes. Okay, so now let's come to trial. Now suppose these are the evidences which are given by prosecution that the accused has committed this crime. So first, it is the BOP on prosecution to prove that accused has conducted this crime, which is punishable under so and so section of IPC. Okay, then here once the prosecution fulfills his burden of proof, then the defense evidences start here, and it is here that the defense of general exceptions is taken. Can anyone tell me why the court itself do not take this uh, defense for the accused? Why, since it is already present in our IPC, we have around 31 sections over there. So why does the court not itself raises this plea that the case of the accused is covered under this general exceptions, and hence the accused should not be convicted for the offense. Hence, the trial is a vague exercise. We should not be allowing the prosecution witnesses as well, right? It will lead to what we say, saving of the time of the court, instead of like obviously this the time which was taken by the prosecution here will be saved. Tell me, why do you think that these uh, uh, the defense of general exceptions is not raised by the court at this point only? If the court or the defense would have raised this plea here, then this prosecution, the time of the prosecution would also have been saved. Hmm. Okay. So what happens is the defense of general exceptions is not something which can be raised by the court. Firstly, because of presence of section 105 of Indian Evidence Act. What does section 105 of Indian Evidence Act tells us? Let me read out for you. Yeah. Section 105 talks about burden of proving that case of accused comes within exception. Okay. So it says when a person is accused of any offense, listen to me carefully, guys. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exceptions or within any special exception or proviso contained in any other part of the code Code means IPC, Indian Penal Code, or in any law defining the offense. I told you offense are defined in other sections also, in other laws also, or in any law defining the offense is upon him. Him here refers to the accused. Okay. And the court shall presume. They are giving a shall presumption here. They are saying it is a shall presumption. Shall is always a mandatory presumption. Not always, rather in most of the cases, shall means a mandatory presumption. Shall presume the absence of any such circumstances. Circumstances, which are the circumstances? Circumstances which they talked about in the second part, in the first part. That is, when a person is accused of any offense, the burden of proving the existence of the circumstances. These circumstances they are talking about in the later part of the section, and it is saying that the court shall presume that these circumstances did not exist unless and until the defense raises the objection that that's the so and so situation existed, and hence he should be given an offense. Since this, because of this defense, the the elements of crime, that is the actus reus and mens rea, do not overlap. Hence these are the do not overlap, or do not we say accompany each other. Hence the particular case falls under one of the exceptions. Hence it should, the society or the what we say state should have a sense of forgiveness towards the accused, and hence he should not be punished. Tell me, have you guys understood whatever I just now told you? Tell me, are you guys following? Please repeat. Okay, okay, I will repeat. I just can you just take out this section 105 in your barracks? This will make things easier. Okay. So just look at the first part of section 105. When a person is accused of any offense, okay, suppose in our case the person is accused of section 302, that is murder. Okay, the burden of proving the existence of circumstances bringing the case within any of the general exceptions in the Indian Penal Code, or within any special exception or proviso obtained in any other part of the same code, or in any law defining the offense, is upon him. Upon him refers to the person who has committed murder. Suppose A committed the murder of B. So if he has committed the murder of B, so it will be, the case will be like this: state versus A. Now state will prove the case. State will prove the case through prosecutor. Prosecutor will prosecute. Prosecution will be done by presenting evidences. Suppose, let's suppose A committed murder, or A killed B by using a gun. So this gun, if recovered by the police, will be produced as one of the evidence, and the bullet shot upon B, the picture of bullet shot upon B will also be produced in the court as evidence that this is the gun from which A actually shot B, which resulted in the death of B. And this death is something which is the consequence of human conduct. And this consequence, this death is the consequence of human conduct. Consequence of whose conduct? Consequence of A. A's conduct. This, okay, just a second. Yeah, section 300 is murder, you are right. But section 302 is what tells us about the punishment of murder, right? Section 300 defines murder. Section 302 tells us the punishment about murder. Yesterday I told you na, that how charge is framed. Charge is framed as that so and so accused has committed the offense of murder. Suppose I took the example of murder only, of murder defined under section 300 and is made punishable, defined under section 300 and punishable under section 302, then and is within the cognizance of, tell me, who tries murder? Is it the civil court junior division or the court of session? It is always court of session and is within the cognizance of court of session. That is how the charge is framed. Okay, yes, sessions. I told you yesterday only that this is how the charge is framed. Once the investigation is completed, then we have this police report, which can be either in the form of closure report or charge sheet. And once it is forwarded to the magistrate or in or to the court, then it is the court who decides that this so and so case, if the ingredients are fulfilled, then the case falls in so and so offense, and hence we have this uh, this hence should be and this hence the trial begins, and thereafter the person starts the court of session or the magistrate, as the case may be, he starts with framing of charge. It is charge framing, and charge is framed the way I just now told you, that you so and so has committed the offense of this and this, defined under this. Okay. Okay, so I was here. Yeah. So suppose this is the death. Death is the consequence, and this consequence is the consequence of human conduct. In our case, which was the consequence of act of A. Okay. Yeah. In our case, it was the act of A. Okay. Then the trial starts. And the prosecution starts by giving the evidences. In our case here, the gun will be produced by the prosecution. Okay. Now suppose we have this prosecution is able to prove this case. It has fulfilled its burden of proof. That is, the accused has committed the offense of murder. For this, he had to prove first that that was caused, that was the actus reus. Then he used a weapon, gun, so he had the intention of causing death as well. Hence, mens rea is proved. Okay. Once mens rea and actus reus are established, then the only thing which is left to be remain to be proved is that the mens rea was of A, and it was A who committed the act which was forbidden by law, and this act which was forbidden by law has been committed by A and A only. This is what has to be proved by the prosecution. Once the prosecution proves this, then we say that burden of proof on prosecution, that the prosecution has discharged its burden of proof. Okay. Then the defenses of evidences of defense starts. Now here, let's suppose in our case B was unsound. He was suffering from a disease called schizophrenia. Many of you must be aware of this disease. It's something like this. Okay. Schizophrenia. And this disease is a medical condition. Okay. Now, if the defense, now what will the defense prove? What will be the evidences which the defense will have in order to take the defense of this unsoundness or the medical condition? Tell me. In order to take the defense of section 84, that is legal unsoundness, what are the evidences which can be produced by the accused, that the accused was not in his senses at the time of doing the at the time when he committed the particular act? What are the things or the evidences which can be proved? Look, no one was present at the time when he killed B. He committed murder. If someone was present, then we can have eyewitness as well. But that will not be used as a defense. That will be used by prosecution here, that it was A and A only who shot upon B. Right? So what are the defenses which are available for B? That is, he was unsound. Look, the only and only defense which is or the evidence which can be used by B for his defense here is this medical condition thing, that he had a medical condition, and for that we have some documents, right? We have some documents that these may be the reports or the some maybe some medical condition, or maybe he was prescribed some medicines for his medical condition. So these are the things which can be produced by the defense at the stage of once the BOP has been discharged by the prosecution and the burden of shifts towards defense. Then these are the things or the evidences which can be produced by B in our case, to prove his medical condition and take the defense of section 84, that is legal unsoundness. Okay. Now guys, tell me if you guys have understood, or I will try to explain once again. Okay. Yes. So suppose you have, suppose in our case A and B, murder, the charge of murder has been framed. A has, A is our accused, state is trying or prosecuting A, and you are appearing for A. Suppose you are appearing for A, all of you are appearing for A. First defense or first evidence which you can produce is medical report. I just now told you. What are the other things which you can produce in order to take the defense of medical of legal unsoundness? Tell me. His history. Yes. Correct. Correct. Correct to some extent. His conduct. Conduct which is past, that is before he committed murder. What was his conduct before he committed murder? And what was his conduct after he committed murder? Okay. So these the defense of section 84 is not I would say a easy defense to prove. It is very difficult to bring evidences in order to establish that the defense of section 84 is available, because medical reports obviously they can be forged as well. Okay, in India I would say they can be forged as well. If the prosecution, if even if the prosecution has not proved that these are false, still the court will not be very much satisfied with these medical reports, because these are in many cases forged as well. So basically it is the conduct which is to be seen. And conduct, as I told you earlier also, relates to actus reus. And in order to take the defense of section 84, we are basically proving the absence of mens rea, right? Since mens rea was not there, hence it is not a crime, hence it is covered under general exceptions, hence it does not shake the societal conscience. Therefore, he should not be convicted, and this necessarily implies that society should have a sense of forgiveness towards him, right? Are you guys being able to make out what I am saying? So, in order to uh, determine mens rea, it is always the conduct and the conduct of the accused which is seen, because mens rea is something which is inside the mind of the accused, and you cannot peep into the mind of the accused to know whether he had the requisite mens rea or not. You have to see the mens rea of the accused from something which is outside. And what do we have outside? Outside we have the act or the conduct which is overt, right? An overt act, and mens rea was inside, hence it was hidden or covert. Tell me, have you guys followed this? Whatever I just now told you. Okay, let's take a break for 5 minutes, and thereafter we'll continue. Just take a just have this thing in mind, and once you have been able to, I am leaving this here. Just apply your own minds over it, and then I will continue with the list part. Okay. Hi. So we are after the break. Now, guys, if you have any doubt, kindly let me know, because otherwise I will be moving to the other section now, because section 84, as far as my knowledge is concerned, is complete. Tell me if you guys have understood it or need any other explanation for this. Just just tell me. Just last one thing which I would like to mention about section 84, and this applies to other exceptions also, is that suppose in a murder trial, like we took the example of murder earlier also. Suppose it is from here that our accused, or A in our case, A started committing some acts. Okay. So it is not a single isolated act. Always it is accompanied by other acts. Suppose this was the main act by which this act is the main act. That is the act of shooting by gun. So his preparation must have started from here, where wherein he first purchased a gun from a shopkeeper. Now this shopkeeper may be brought as an prosecution evidence here, right? So he purchased a gun. Thereafter, he purchased some bullets of the gun. Then he, in order to commit the murder of B, he had what we say, had made prior planning that at this particular time, at this particular day, at this particular time, on this particular day, B comes to this area wherein he will have the opportunity of shooting B, and this shooting that I told you, since it is a trial of murder, so this shooting will have the A must have the intention of causing death of B. So he must have planned it according to the intention. That is the highest degree of mens rea which is required, and hence he must have made all the preparations that that once he has given a gunshot to B, in all probabilities B must die. This must have been the prior planning of A, right? So he must have done he must have done various acts before committing the main act, that is the shooting. So section 84, what 84 talks about, that what I told you is this thing, that nothing is an offense which is done by a person who at the time of doing it. Okay, so at the time of doing it, no one was there, the court was not there, and he is being tried before the court, but the court was not present at that time, right? So since the court was not present there, so how will the court know what was the mens rea at that time? How will the court know? The court will look into the circumstances here and the circumstances which were present here, and this was the main act of shooting. Okay, and from these circumstances, which the acts of the or the circumstances which were present before and after the act was committed, it is from these circumstances the court will deduce the mens rea, if he had the requisite mens rea for the offense of murder. And if the prosecution, or if the defense is able to prove that he did not have the mens rea at the time of this act, at the time of the shooting, then A will get conviction. Oh, A will get acquittal, and he will not be convicted? Okay, guys, tell me, are you following or not? Because otherwise it won't be a, it will be rather a futile exercise altogether, which will lead to wastage of yours as well as my time. Tell me if you guys have understood this or not. If you guys are able to comprehend whatever I am saying, if you guys are following whatever I am saying. Okay. So section 84 is done. Now, guys, I must tell you that section 84 is the section which is most used, because apart from this, none of the other sections have I ever come across in my litigation practice so far, though it is short practice at this point of time. But I have never come across any other defense apart from section 84. So that's why I took this section and tried to explain you in quite detail. I don't think after this you guys will ever get stuck in this section. Okay, I received a message that you have not understood it. Okay, let me give you an example also. Yeah, this example will make everything very much clear. So let's suppose A committed murder of B. Okay, now before committing of murder, or A killed B. Before killing of B, A bought the gun. A bought bullets. He also made the preparation. He practiced gun, how to shoot from a gun. These are all the acts which will be seen at the trial. Okay. And once he killed B, then we enter another stage. Once A has killed B, then we enter the another stage. And this here, what did A do after killing B? He just ran away, or he, in order to, like, in order to get a acquittal, or in order to not get arrested, he tried to make attempts. He tried to run from the police. He tried to hide the body of B. He cut down the body of B into various pieces. Okay, so what are these? These are the conduct of A, which will give us the mens rea, or the state of mind of A at the time when he killed B. So from these circumstances, we would be able to make out that A was mentally sound or not. And if we are able to prove that he was unsound, then section 84 defense is available and will be granted. And if, since he tried to run, he tried to hide the body, he bought gun, bullets, he made prior preparation. These are not the these conduct clearly suggests that he had the requisite mens rea, and he was sound. He had the requisite mens rea. All these suggest that he had the requisite mens rea, and he was mentally sound, because these are what a reasonable person would do after committing a crime. He would try to run away. He would try to hide whatever the consequence has been done by his act. He would try to hide it in order to escape the liability. These are what are these? These are the conduct of the accused, which enable us to get to find out the mens rea of the accused. Okay, so these are the things which will help us to determine the mens rea of the accused, and in order to see whether section 84 is the defense of section 84 is available or not. Okay, if you guys have not understood now, tell me, I will explain it again. No issues on that. Okay, now we are left with very small sections. These are just a bare act reading of these section would suffice. So section 76. Section 76 talks about a person who believes himself to be legally bound. Okay, let's discuss section 76 now. To these stages of crime. Yeah, I will explain it. Don't worry. Stages of crime. I will explain it. Yeah, legally bound. Oh, I took out the bare. Yeah, are you guys able to now this? I think now it should be visible, right? Bare act is visible to you, right? So section 76 tells us act act done by a person bound or by mistake of fact believing himself to be bound. Okay, so both the circumstances are covered here. Either he thinks himself to be bound, or he thinks that he, under mistake of fact, believe himself to be bound. These both are covered here. Bound or mistake of fact, believing himself to be bound. Now here also it starts with the term nothing. That is no thing. I told you now, which we read about in section 84, in section 40. Nothing is an offense which is done by a person who is, or who by reason of a mistake of fact, or and not by reason of mistake of law. What are they trying to imply here? They are trying to imply ignorantia non excuse. If you have heard about that maxim, ignorance of law is not an excuse. In good faith, believes himself to be bound by law to do it. Okay, this is a simple bare reading of this section 76, and it has I just be telling you simple thing about this. It talks about legally bound or under mistake of fact things to be legally bound. Okay, so this they are talking about mistake of fact here and not law. Remember this, it is not mistake of law because of the maxim ignorantia lex non excusat. Ignorance of law, no excuse. Okay. Remember this thing. It will help you in later stages of the class. Now, now let's come to section 77. There is hardly anything to explain in these sections. These are plain reading would also suffice. Okay. What does section 77 tell us? Act of a judge when acting judicially. Okay. Act of a judge when acting judicially. Nothing is an offense which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law. Guys, did you guys think what this good faith actually is? Again and again, they are saying us in good faith, in good faith. What is this good faith? Good faith is something which is defined under section 52. Okay, just read that definition of good faith given here, and if you guys do not understand, then let me know, because it is taking us a lot of time, guys. We need to sum up this session, and in a later session also we we will be having a lot many things to do. Okay. Yeah. So nothing is an offense which is done by a judge when acting judicially in the exercise of any power which is or in which in good faith he believes to be given to him by law. This thing has to be kept in mind. Judicially in exercise of any power which is or which in good faith he believes to be given to him by law. This means he was when he was doing that act, he was thinking himself either he was justified by law or he was thinking himself to be justified by law, as that power was given to him by law. Okay. Now, section 78. Act done pursuant to the judgment or order of court. Okay. Nothing which is done in pursuance of or which is warranted by the judgment or order of a court of justice, if done by such judgment or order remains in force, is an offense, notwithstanding the court may have had no jurisdiction to pass a judgment, provided in person doing the act in good faith believes the good. So, what does this section 78 is trying to tell us is nothing is an offense done in pursuant to a judgment. Okay. So let me tell you a very important point here, that section the defense of section 82, as asked by, I would say, n number of exams as well, is available to a hangman. Hangman, do you know who is a hangman? Hangman, hangman is the person who executes death warrant, right? He is the person who executes death warrant. In Hindi, we call him Jallad. Capital punishment. Yes. Okay. So since he is acting under a judgment, so this hangman comes within the exception of section 78. Basically, what the hangman is doing, he is committing the offense of murder because he is hanging the accused, or he is hanging the accused according to the judgment. That's why he is is convicted. This person has been convicted by the court through a judgment, and this judgment is being executed by the hangman. Okay, so here the hangman will get the defense of section 78 as he is acting under the judgment of a court. Okay, now we have section 79. Act done by a person justified or mistake of fact believing himself to be justified by law. It is quite similar to section 76 only. Okay, similar, not same. Section 79 talked about bound by law. Here they are talking about justified by law. There is a difference. If I take an example, here they are basically talking about a police officer or the officers in what we say public administration, or those who are responsible for maintaining law and order. But here we are talking about someone who is not a public officer, or maybe a public officer, but generally if he is a public officer he will fall in this section. But if he is justified by law, we have some provision wherein even a private person can arrest a person if a non-bailable and cognizable offense is committed in presence of that person. So that person can arrest. Okay. So here this person will be covered by section 70. I wrote it here. It's not justified. 76 is about bound. Yeah, it is about bound by law. And it is section 79 is justified by law. Okay. Here it is bound. Here it is justified. Here we have the example of a private person. Here we have the example of a police officer. Okay. Guys, tell me if you guys are following or not. Now we have section 80. Now section 80 is accident in doing a lawful act. Okay, nothing is an offense which is done by accident or misfortune. Done by accident or misfortune, or without any criminal intention or knowledge. They are talking about intention as well as knowledge. I told you in the initial part of the class that mens rea is of three types: intention, knowledge, and reason to believe. They are talking about intention and knowledge here, not reason to believe. Here, reason to believe is not mentioned. In the doing of a lawful act in a lawful manner, by lawful means, with proper care and caution. Okay. So they are just talking about accident cases, accident or misfortune. Okay. So if you guys have not followed this, let's take the help of illustration also. What does the illustration tell us? A sees Z. No, A is at work with a hatchet. Hatchet. What is hatchet? What is an hatchet? Hatchet is an axe. Okay. The head flies off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, just what is meant by lawful manner and lawful means? Okay, look, lawful manner and lawful means is nothing but something which are which is we say not like I told you, crime is basically offense against state. Okay, so this is what is an unlawful, something which is not justified by law. But if some person is doing a lawful act means suppose mm, suppose the person is having his what we say, suppose someone is selling his piece of land, which he is the which he is the owner, as well as he is in possession of that land. Okay, this is a land. So this is a lawful act. Who says it is not lawful? It is a lawful act. If he is the owner and he is in possession of that land, he has a right to sell off this land. It is lawful act. And if he has employed lawful means, lawful means this means that he did not commit any forgery while framing of sale deed. He did not misrepresent. The land was what would have been misrepresentation. The land was of suppose 1 hectare, and he in papers he mentioned it that it was of 2 hectares. Okay, so this is what is lawful means. This is what is lawful act in lawful means is. Okay, so guys, let's limit ourselves till section 80 today. If you guys have any doubt or anything else which I can explain to you, kindly let me know, because I have been receiving phone call as well that one of you need to leave. So we will maybe tomorrow, if possible, we can start a little bit early, and we can start the session maybe at 5:30 or 5:40. Then maybe we can we would be able to cover more topics in one class. So after this, we are left with what we say, section 81. Section 81 is also nothing more. It's act likely to cause harm. We have it basically it relates to necessity. Okay. Then we have section 82. It's I told you it's a section of minority, that is act done by a person below 7 years of age. Thereafter, we have section 83. Section 83, I told you that it is a It is also a case of minority, and here they have mentioned the act done by a person below 12 years of age. Section 82, what is talks is in sections, if the person who has or the accused is below 7 years of age, then he is completely exempted, no questions asked. But section 83 talks about if the person is below 12 years of age and above 7 years of age, and he has the capability of understanding, and he has the uh, what we say, maturity of knowing the nature of the act or what he is doing, or the nature of the act, or that the act which he is doing is lawful or unlawful. So these are the things which are seen before the person is acquitted or convicted in section 83. Section 84 we have discussed in quite brief, in quite detail rather. Now now section 85. Section 85 is basically intoxication, and I will explain these sections to you tomorrow. Don't worry about them. And if you guys have any doubt relating to today's topic, kindly let me know. Otherwise, we will be winding up and you can start leaving. Okay. Okay, guys, you may start leaving.